Okay, let's talk about something pretty tough, losing a job. It's a huge life event, right? And in that moment, all you want is clarity on what you're actually owed. But here's the thing. What if that common knowledge, that thing everyone thinks they know about termination pay, is just plain wrong?
So let's make this real for a second. Picture it. You've just been let go. Your employer slides a severance package across the table. How in the world are you supposed to know if it's a fair deal? What does the law actually say you're entitled to? It's a huge question, and believe me, the answer isn't as simple as you think.
I bet you've heard this one before. We all have. The classic rule of thumb. For every year you worked somewhere, you get 1 week of pay. It sounds neat, it sounds easy to calculate, and honestly, for most people, that's the beginning and the end of the story. But what if I told you that simple little rule isn't just a bit of an oversimplification, it's a misunderstanding that could be costing people thousands, maybe even tens of thousands of dollars? The truth is, your real entitlements are governed by two completely different legal systems playing out at the same time. So let's start with the basics. In Ontario, that's the Employment Standards Act, or the ESA. And the government is really clear about this. The ESA sets out the absolute rock-bottom minimums. It's not the standard, it's the starting point. Think of it as the legal floor. An employer cannot legally go any lower. To make things even more interesting, the ESA actually breaks down what you might get into two different buckets: termination pay and severance pay. And no, they are not the same thing, even though we all tend to use the words interchangeably. Termination pay is basically pay instead of notice. Severance pay, that's more about compensating you for losing your seniority after you've been there a long time. And would you look at that? Right here is where that 1 week per year myth comes from. This is the official chart for termination notice under the ESA. And yeah, for years 3 to 7, it is 1 week per year. But, and this is a huge but, look at the bottom. It caps out. Once you hit 8 years of service, the legal minimum is just 8 weeks. That's it. Period. Okay, so what about that other bucket, ESA severance pay? Well, that only even comes into play if you clear two pretty high hurdles. First, you need at least 5 years of service. And second, your employer has to be a big company, either with a global payroll of $2.5 million or they're in the middle of a mass layoff. If you don't check both those boxes, your ESA severance is 0. So here's the most important thing to get so far. If an employer offers you a package that just meets these ESA minimums, they are doing the absolute bare minimum required by law. They are standing on the very lowest rung of the ladder. And listen, this isn't some secret legal loophole. This is written right in the government's own guide to the ESA. It literally says that some folks might have greater rights under something called the common law, and that is the part of the story that almost everyone misses. So, welcome to the common law. What is it? Well, it's not a law written down in a book like the ESA. It's law built up over decades and decades of court decisions. And here is the absolute key. Unless your employment contract specifically and legally limits you to just the ESA minimums, it's the common law that actually determines what you're owed.
And the common law doesn't use a simple formula. It talks about something called reasonable notice. To figure that out, courts look at a few things, often called the Bardal Factors. They look at your age, because, let's face it, it can be harder to find a new job when you're older. They look at how long you worked there, what kind of job you had, were you a senior executive or in a very specialized role, and finally, what the job market looks like right now. It's all about what's fair in your specific situation.
And this, right here, this is the whole ballgame. This is the legal gap we're talking about. On one side, you have the ESA, a strict, simple formula that maxes out at 8 weeks. On the other hand, you have the common law, a flexible, fairness-based approach that often results in notice periods between 2 and 24 months. I mean, we're not talking about a small difference here. It's a completely different universe of what you could be entitled to. So theory is great, right? But what does this gap actually look like when it plays out in the real world? Just how big of a difference are we talking about here? Well, let's take a look at a real case. It's called Pavlov versus the New Zealand and Australian Lamb Company. The Ontario Court of Appeal was looking at the case of a senior employee, 47 years old, who had been let go. And how much notice did the court say was reasonable for him? 10 months. Now get this, he had only worked at the company for 3 years. Under the strict ESA formula, he'd be owed 3 weeks. The difference wasn't a gap, it was a canyon. So why? How is that even possible? It all comes down to the fine print. The single most important piece of paper is your employment contract. In this case, the court found that his contract didn't have a properly worded enforceable clause that restricted him to just the ESA minimums. And without that legal chain, he was entitled to the full protection of the common law. And you know what? The courts are getting incredibly tough on these clauses. There was a huge case in 2020 called Walksdale that basically said if any little part of a contract's termination section breaks the ESA rules, the whole thing gets tossed out. It's like one bad apple spoils the whole bunch. And when that happens, employees automatically get bumped back up to their full, much more generous common law rights. So if you only remember one thing today, please let it be this. The Employment Standards Act, that's the floor. It's the absolute legal minimum. But for so many employees, the common law, that's the ceiling. That's what's actually fair. And the space between that floor and that ceiling can literally be life-changing.
Which brings us to the one question you need to ask. If you're ever looking at a severance offer, you can now look at it with new eyes and ask yourself, is what they're offering me the bare minimum? Is it the floor? Or is it closer to what's fair? Is it the ceiling? Knowing there's a difference is everything.